Hello everyone, welcome back to Legally Dephine. In this video, we are diving into the lawmaking process in Zimbabwe. This shall be a two-part video where we will explore the different state organs and their powers, and then take a closer look at how laws are made in Parliament. Make sure to subscribe and hit the notification bell so you don't miss on part 2. Let's get started. In Zimbabwe, the rules defining the structure and powers of state organs are embodied in the Constitution. It is mainly to these documented rules that reference must be made in order to understand the powers of governmental organs. Answers to the following questions are all a matter of constitutional law. Number 1, which organs make law? Number 2, what are the requisite lawmaking processes? Constitutional law utilizes the principle of separation of powers. The principle of separation of powers requires that, as a guarantee for the liberty of an individual, political power must not be concentrated in one individual or organ of state. It requires that governmental functions must be separated into 3 different groups and each be performed by different individuals. This is thought to be a way of creating checks and balances by one organ against another. The 3 main organs of government are the Legislature, the Executive, and the Judiciary. Therefore, the organ which makes law, the Legislature, must be different from the organ which implements it, the Executive, and must be both different from the organ which interprets it in the event of a dispute, the Judiciary. Although Zimbabwe has adopted the basic framework of creating 3 different state organs in terms of the principle of separation of powers, it has not fully embraced the strict separation of governmental functions into different individuals and organs. A brief description of the structure and functions of the key governmental organs is essential for an understanding of the lawmaking process in Zimbabwe. Starting with the legislature, a principal function of the state is that of making laws for the proper ordering of the society. This important function of the state is allocated to the legislature, which is in terms of Section 116 of the Constitution. The legislature of Zimbabwe consists of Parliament and the President, acting in accordance with this chapter. Parliament, in terms of Section 118 of the Constitution, consists of the Senate and the National Assembly. For a law to be called a law made by the legislature in Zimbabwe, it must pass through 2 stages. First, it must be passed by a requisite majority by both houses of the Parliament. Second, once it has been passed by Parliament, it has to be assented to by the President before it becomes law. This second stage makes the President very much part of the legislature in Zimbabwe. The President is a different organ from Parliament, but he has the power to accept or reject laws that it has passed. Even though the President is also the head of the executive which implements the law, this state of affairs essentially allows the executive to have a final say on the lawmaking process. What then happens if the President decides to reject a law duly passed by the Parliament? Section 131 of the Constitution provides steps to be taken in the event that the President rejects a law passed by the Parliament. When a bill is presented to the President for assent and signature, he or she must within 21 days either assent to it and sign it and then cause it to be published in Gazette without delay, or if he or she considers it to be unconstitutional and has any other reservations about it, refer the bill back to Parliament through the Clerk of Parliament, together with detailed written reasons for those reservations and a request that the bill be reconsidered. In simpler terms, if the President is presented with a bill in terms of Section 131 subsection 6 of the Constitution, he has 2 options: either agree to it or refer the bill back to Parliament. Composition of the National Assembly. In terms of Section 124 subsection 1A and B of the Constitution, the National Assembly consists of 210 members elected by secret ballot from the 210 constituencies into which Zimbabwe is divided, and for the life of the first two parliaments after the effective date, an additional 60 women members, 6 from each of the provinces into which Zimbabwe is divided, elected under a party list system of proportional representation based on the votes cast for candidates representing political parties in a general election for constituency members in the provinces. The National Assembly is presided over by a Speaker who is elected by the members at their first sitting in terms of Section 126 of the Constitution. A person is qualified for election as the Speaker if he or she has been a member of the National Assembly, or if he or she is qualified to be elected to the National Assembly. If a member of the National Assembly is elected Speaker, he or she ceases to be a member and his or her seat becomes vacant and a by-election is called. In terms of Section 120 of the Constitution, the Senate consists of 80 senators, of whom 6 are elected from each of the provinces into which Zimbabwe is divided by a system of proportional representation conforming with subsection 2. 16 are chiefs, of whom 2 are elected by the Provincial Assembly of Chiefs from each of the provinces other than the metropolitan provinces into which Zimbabwe is divided. The President and Deputy President of the National Council of Chiefs, and 2 are elected in the manner prescribed in the electoral law to represent persons with disabilities. The Senate is presided over by the President of the Senate, who is also elected by the members at their first sitting in terms of Section 122 of the Constitution. If a senator is elected President of the Senate, he or she ceases to be a senator and his or her seat becomes vacant and a by-election is called. Apart from its lawmaking functions, Parliament also has the power to supervise the executive arm of government by, among other things, criticizing government policies. Through this role, Parliament has the power to institute investigations into any activity of the state and to publicize its findings. This power can be used to ensure accountability on the part of government ministers. The most important manifestation of this power is the question and answer session in Parliament, where parliamentarians are required to ask government ministers any questions pertaining the conduct of government, and the ministers are obliged to answer those questions truthfully. The answers given in Parliament are essentially for the benefit of the public. Therefore, members of the public seeking answers to questions of public importance may do so by asking their MPs to post relevant questions in Parliament. If you find this lecture beneficial, please hit on the like and subscribe buttons. Don't forget to click on the notification bell so you never miss on our latest lectures. Your support greatly helps us continue with our work here on Legally Dephine. Let's continue with the lecture. The executive arm of the government is composed of the President, the Cabinet, and all law enforcement agencies, namely the police, the military, and the prison service. The ultimate authority of the executive functions of the state are vested in the President, who exercises most of his functions through the Cabinet in terms of Section 88, subsection 2 of the Constitution. The President is elected for a 5-year term by all registered voters. There is currently no limit to the number of terms a person may serve as President of Zimbabwe. In terms of Section 95, subsection 2 of the Constitution, the term of office of the President or a Vice President extends until he or she resigns or is removed from office, or following an election, he or she is declared to be re-elected, or a new president is declared to be elected, and their terms of office are 5 years and coterminous with the life of Parliament. The role of the executive arm of government is to implement laws made by Parliament and to run the affairs of the state. The executive functions of the President and the Cabinet are in terms of Section 110 subsection 2 of the Constitution, and in the exercise of his or her duties, the President must act on the advice of the Cabinet. The judiciary is an arm of the state. However, judges are required to be independent in the discharge of their duties. Section 164 of the Constitution provides for the independence of the judiciary. Section 164 of the Constitution reads, "The courts are independent and are subject only to this Constitution and the law, which they must apply impartially, expeditiously, and without fear, favor, or prejudice." The independence, impartiality, and effectiveness of the courts are central to the rule of law and democratic governance, and therefore, neither the state nor any institution or agents of the government at any level and no other person may interfere with the functioning of the courts. The state, through legislative and other measures, must assist and protect the courts to ensure their independence, impartiality, dignity, accessibility, and effectiveness, to ensure that they comply with the principles set out in Section 165. An order or decision of a court binds the state and all persons and governmental institutions and agencies to which it applies, and must be obeyed by them. This independence of the judiciary from the other two arms of the state is the cornerstone of the principle of separation of powers. The function of the judiciary is to interpret the law, something that the other two organs of the state cannot do. Therefore, the privilege to interpret the law lies only with the judiciary. One of the important functions of the judiciary in Zimbabwe is adjudicating on the constitutionality of acts of parliament. An act of parliament or any other law which contravenes the constitution can be declared unconstitutional by the Constitutional Court in terms of Section 167 of the Constitution. This power of the Constitutional Court to determine on the constitutionality of acts of parliament puts an independent judiciary in a secure position to exert checks and balances on the powers of the executive and the legislature. However, by a proper amendment of laws, Parliament can overturn certain judgments of the courts. The division of government organs into three main groups can mask certain bodies which require separate treatment, the most important of which are the Office of the Attorney General, the Auditor General, and the Public Protector. Attorney General is another important organ of the state and is appointed by the President. In terms of Section 114, subsection 4 of the Constitution, the functions of the Attorney General are to act as the principal legal advisor to the government, to represent the government in civil and constitutional proceedings, to draft legislation on behalf of the government, to promote, protect, and uphold the rule of law and to defend the public interest, and to exercise any other functions that may be assigned to the Attorney General by an Act of Parliament. As a legal advisor to the government, he or she sits without voting rights in both the cabinet and the parliament. He or she represents all government departments in all actions that may be brought against them in court. The Auditor General is a public officer appointed by the President with the approval of Parliament. The functions of the Auditor General in terms of Section 309, subsection 2 of the Constitution are to audit the accounts, financial systems, and financial management of all departments, institutions, and agencies of government, all provincial and metropolitan councils, and all local authorities. At the request of the government, to carry out special audits of the accounts of any statutory body or government-controlled entity, to order the taking of measures to rectify any defects in the management and safeguarding of public funds and public property, and to exercise any other functions that may be conferred or imposed on him or her by or under an Act of Parliament. The Auditor General is required to report to Parliament all his or her findings and to be completely independent in the discharge of his or her duties. Once reported to Parliament, these accounts become available to the members of the public. The report of the Auditor General is a useful source of information for the members of the public to use for the purposes of criticizing government on the use of their finances. Clause 17 and 18 of the Constitution of Zimbabwe, Amendment Number 2 Act of 2019, create the Office of the Public Protector, who will take over certain functions concerning public maladministration, etc. from the Zimbabwe Human Rights Commission, and it amends Section 243 of the Constitution, Functions of the Zimbabwe Human Rights Commission. One of the most progressive judgments made in 2016 by the Constitutional Court of South Africa was the Nkandla judgment, wherein the court dealt definitively with matters important to the evolution and application of constitutional democracy, such as the separation of powers among the judiciary, the legislature, and the executive, the roles and tasks of the executive, especially the duties of the President of the Republic, the roles and tasks of the judiciary, the roles and tasks of the National Assembly, and the roles and tasks of the Public Protector. Make sure to read the case, it's a very interesting read, and the full citation is on the screen. That wraps up state organs and their powers. Make sure to watch part 2 where we will explore the lawmaking process in Parliament. Thank you for watching and don't forget to subscribe.